Cryptocurrencies. Are they here to stay? Among the leading cryptocurrencies, Ripple is one of them because of the awe-inspiring and innovative endeavors which are helping it to establish the peak position. Is Ripple creating ripples in the crypto sea? Watch the video till the end to not miss an important update on Ripple. Welcome to How to Crypto. The news updates on cryptocurrencies. And today we'll be talking about the SEC versus Ripple lawsuit. If you want to stay up to date with all the crypto news, you need to like and subscribe. Don't miss anything. Be aware of bulls and bears in the future. On 22nd December 2020, the Securities and Exchange Commission stated that Ripple Labs Inc. and two of its managers, who are also essential holders of the securities, have filed proceedings alleging that they have generated over $1.3 billion through an unregistered digital asset stock offering. The San Francisco firm's defense case had looked dead in the sea earlier this year, but according to legal commentators, the tide could potentially change in favor of Ripple. A few days before Christmas 2020, the SEC filed an action claiming that its founders had illegally sold its native XRP coin to retail users, allowing the company to raise its capital as unregistered security offering through its sales. In breach of federal law, SEC prosecutors alleged that they did not register sales. They also allege $600 million for the orchestrated personal unregistered sales of Ripple chairman Christian Larson and CEO Brad Garlinghouse. At that time, Garlinghouse described the issue as a crypto assault, claiming the SEC is fundamentally wrong in law and fact, before reiterating that the founders wanted to upset their California headquarters and shift the business to a different country. Now it appears that the chances are now with Ripple, 6 months on or after a series of bruising battles. Issuers seeking the public offering benefits including retail, investor access, broad sales, and a secondary market must comply with the federal securities legislation that requires offer registration without a registration waiver, said Stephanie Avakian, director of the SEC Enforcement Division. They claim that Ripple, Larson, and Garlinghouse have not recorded their continuing offering and sales to retail investors of billions of XRP, thus depriving potential purchasers of sufficient disclosures of XRP and Ripple's business and other necessary long-term safeguards essential to our robust public market systems. Ripple's growth is hindered mostly owing to the litigation against the firm by the US SEC. Still, it is moving forward to build its worldwide payment business, Brad Garlinghouse, CEO of Ripple, stated in CoinDesk 2021 Consensus Conference on 27th May. "We are seeing activity growth every 10 years in Southeast Asia, one of our fastest growing segments," said Garlinghouse. The company saw 40% network transaction growth on a quarter-to-quarter basis last year. Still, it curtailed growth after the SEC launched its complaint against Ripple in December 2020, claiming that its XRP sales stood at over $1.38 billion in unregistered securities. Following the complaint by the SEC, numerous US exchanges have delisted XRP, and MoneyGram has also suspended its collaboration with Ripple, the world's second-largest money transfer business. Garlinghouse added MoneyGram and Ripple have a substantial ODL, on-demand liquidity transaction, of about several $billion. He claimed that in the hope of regulatory clarification, they had stopped this partnership. However, Ripple remains dominant in Asia, particularly Japan, and also looks at providing service to the new and rising area of central bank digital currencies, CBDCs. CBDCs are good at eliminating friction and payments on a domestic basis. For this cross-border efficiency, Ripple is striving to tackle the problem and is using XRP. They have engaged with several governments worldwide and continue collaborating with governments worldwide as part of the public open-source version of the XRP ledger, states Garlinghouse. The lawsuit is now in the discovery phase, with the SEC and Ripple fighting for what information is to be shared with the other party. Garlinghouse said that this is particularly good and is pleased that the judge recognized the nuances and the importance of the crypto case in the United States. Garlinghouse added that Ripple's move, referring to the court order that obliges SEC to share its confidential communication concerning XRP, Bitcoin and Ethereum, was given by the court. It is indeed the first time that a court has ordered the SEC to be transparent. The only request for 2 to 3 years was for regulatory clarity, so this seems to be progress. It's slowly moving, unfortunately, remarked Garlinghouse. I am hopeful that when a new SEC administration comes, it will recognize that some of the earlier SEC rulings will be re-examined. Stating a vast gap in leadership in the United States, Garlinghouse has listed Japan, Singapore, United Kingdom, Switzerland, and the United Arab Emirates as examples of markets where clarity and certainty enable companies to invest and move forward. The court refused the move by the SEC to oblige Ripple to provide documents dealing with XRP sales with the lawyers of the firm, a demand contended by Ripple Labs that contravenes the lawyers' privilege regulations. Precisely because of this, the rationale of Judge Netburn as an attorney-client privilege is aimed to foster full and open communication between lawyers and their customers, and so serve wider public interest in the field of law enforcement and the administration of justice. If Ripple releases its beliefs or relies on its privilege of communication to support its fair defense, the judge, however, permits the regulator to renew that request. The fight over legal counsel, which this month heated the courtroom, is resolved. The main argument of the SEC was the doctrine of fairness. SEC attorney Jorge G. Chenrero told the Ripple lawyers at a hearing that it was a security and that it knew what the law required. Their lawyers knew from the very beginning, and from now on, nobody knew and left us unable to dispute the fundamental unfair nature of the fairness principle recognized on the circuit, displaying all of the counsel they had, not only what they selectively communicated to third parties. The attorney-client privilege stood and gave a much-needed victory for Ripple. A key point, as the defendant remains his affirmative defense, since the SEC has not given a reasonable notice that XRP might be considered a security, particularly after a series of occurrences that would otherwise suggest. In support of its allegations, it cites the violations of Securities of Exchange of the 8-year delay in carrying out enforcement action against Ripple. Even when XRP was listed on more than 200 cryptocurrency exchanges, billions of dollars of XRP sales had been taken. Ripple had entered into a settlement with the US Justice Department and FinCEN that described XRP as a convertible virtual currency. Attorney Jeremy Hogan previously suggested that a Ripple triumph in defense of the fair notice might rescue the industry from the SEC. Any crypto business the SEC sues from that point on becomes a persuasive authority. If the defense fair notice survives and Ripple wins, the SEC will have an uphill battle to win any future lawsuits. It's still larger than that. However, even if Ripple loses the fair notice defense, they can appeal the judgment. And if an appeal court finds Judge Torres to be wrong, and Ripple has no fair notice, the SEC is in a difficult position now because it is binding on all the crypto proceedings that occur. Ripple's spectacular battle with the Security and Exchange Board has gone dramatically since its pursuit of the blockchain-based digital payment business was backlashed by the US regulatory authority. The move in favor of Ripple now adds weight to the defense of fair communication, which contends that the prosecution authorities neglected to warn before the lawsuit was filed. This may well be the turning point of the whole case, argues legal commentator Clive Brabin, which he believes went in favor of Garlinghouse and Larson. Throughout the whole lawsuit, the judgment of Judge Netburn very possibly could be the decisive moment, he said. In search of access to privileged and legally supported records by Ripple's lawyers, the SEC has now hit a wall of brick. It's a crucial issue and emphasizes the fair defense that this whole case might still make or break. It is no secret that when the case with SEC is ended, Ripple expects to go public, but Brad Garlinghouse's CEO has renewed his plan in a Consensus 2021 review. He said that Ripple's chance of being a public firm at some time is very strong. He thinks in the middle of an SEC litigation, you know that they have to stop, and the SEC accepts the S1 procedure. It's easier once you're closed and clear, and we've been looking for regulatory certainty for so long. SBI Group leader Yoshitaka Kitao, a member of Ripple's board of directors, recently took the same view on an earnings presentation call that the IPO would pay off the investment. The XRP price surge after the court's judgment was in its favor. Ripple XRP prices will attain higher milestones in the coming years. As the market begins to observe massive project invasion, other cryptocurrencies can take a step back, and the price of XRP will sway above all. Investment Haven, a crypto active prediction tool, has an ambitious bullish outlook for 2020 since it predicts that 2021 would be a perfect year for Ripple. By 2021, the cost of this crypto asset might climb up to $8 or $10, as XRP says it can have the highest capacity of all other cryptos. So there you have it, and with that we've come to the end of our video. We hope you enjoyed the video, and let us know in the comments how much your crypto will be worth next year. Make sure to subscribe and give a thumbs up. See you tomorrow at How to Crypto with more crypto updates.